Well, Mark Zuckerberg is set to appear in court tomorrow as shareholders seek to hold him and other Meta executives accountable for billions the company spent to settle previous lawsuits. The trial aims to hold them personally liable for the $8 billion spent to resolve allegations that Meta allowed users' data to be harvested without their consent through platforms like Facebook. For more, we are joined by Jennifer Huddleston, who is a senior fellow in technology policy at the Cato Institute. Jennifer, good to have you with us today. Now, this case is known as, it's known as a shareholder derivative lawsuit. Can you explain what that is and why has this been brought against Mark Zuckerberg and other current and former Meta executives?
So this case is a bit different from some of the other litigation we've seen Facebook involved in, which has typically been around some of the questions of antitrust or even some of the debates over, for example, Teams' use of its product. In this case, the plaintiffs will have to show that the executives failed in their oversight duties, that they not only allow these violations to occur, but they did so knowingly, and they did so knowing that they were under this 2012 consent decree. And so that's something to really remember in this case, now that we're talking about this in 2025, is that this is really about events that occurred quite a while ago, and that this is really seeking to imply or allege a very deeply personal level of knowledge of the events that were going on.
And so this does date back to that Cambridge Analytica scandal from 2018, doesn't it?
Absolutely, which I think it's important to remember. While we certainly continue to see debates over Meta and data privacy in general, both here in the United States, where we've seen debates over data privacy at a state level as well as a federal level, as well as around the world, where we're seeing debates over data usage, particularly in the age of AI, that the facts in this case and the allegations around this around whether or not there was this kind of personal knowledge, this question of did they fail in their oversight duties, will really be focusing on events that were more than 7 years ago now. And so when we're looking at this case and we're looking into how it fits into the broader data privacy debate or the broader tech policy debate, it's very distinct from some of the other conversations that are going on and really focuses on what will be a very high burden to prove.
Yes, and I was going to ask you that, Jennifer. How strong is the case against Mark Zuckerberg and those other executives?
Well, I don't know about the exact specifics of the case. I'm not an attorney involved in it. But looking at these type of cases, it's important to recognize that the allegations that a director has failed in their oversight duties is typically seen as something that is very difficult to prove. And when you're thinking about these type of cases as it relates to data, you would have a lot of things to prove around the knowledge of what was going on, the knowledge of the violations occurring, the knowledge around the consent decree and the specifics that it required and how all of this relates in. So it's important to recognize that this is going to be a difficult burden. It's going to require substantial proof of what these executives might have known if the plaintiffs are to succeed.
Yes, and it's quite interesting to know that a number of people will be heard in this case, and that includes, the co-founder of Netflix, a former Biden chief of staff, a former PayPal executive. What is their involvement in this?
So I would say when it comes to these cases, I've focused more on how they relate to data privacy. So I'm not as familiar with the specific involvement of these other executives, but I do think it's important to recognize that we are likely to see greater conversations around data privacy. This is something that's already been going on in the States, but particularly, even though this case relates to these past events, we'll certainly hear conversations around not only how is Meta handling data privacy, but how are some of these other companies handling data privacy, particularly in the AI era.
Yes. So, of course, this Cambridge Analytica scandal, that was 7 years ago, as you mentioned. Have things changed at all when it comes to the privacy of the data that clients like you and me give out to companies like Meta and Google?
So I think there are three key things to think about that may have changed since the 2018 debate. First of which is the emergence of more regulation, both in the states and at a global level. We've seen things like GDPR in Europe go into effect. We've also seen more than 19 US states pass their own data privacy laws, many of which at times may conflict with one another, giving confusion to both consumers and to businesses of all sizes about how to properly comply. The second is the emergence of AI and how AI has perhaps changed some of our perceptions of data privacy and data usage. So when we think about AI and what it means both to interact with these privacy laws, as well as how at times it may actually be more useful to have more personalized data, how some of the questions around AI and concerns about issues like bias may actually be better solved by having more data rather than less data. And then finally are the various steps we've seen different companies take in terms of empowering users to feel like they have more control over their data. And this is really a key point in the data privacy debate, is that we're all going to have different preferences when it comes to what companies we're comfortable sharing what data with. And so companies have taken steps to create privacy checkups or to otherwise allow consumers to really feel like they're the ones in control of the decisions that they're making, and even to remind them at times when these privacy policies change, so that when something new like AI comes about, they can see if their preferences still match their existing options.
And just going forward, Jennifer, and the final question here, but can any government really have ironclad policies and laws to truly govern tech companies and how they treat the privacy of its clients?
When it comes to data privacy, we have a broad range of preferences, and we also have a lot of trade-offs. When we are thinking about the potential regulation of data privacy, there will also be consequences for things like free speech or freedom of the press, or for innovative uses of data that we might benefit from. So I think it's important that when we are considering potential regulation of data privacy, that we consider not only privacy, which we all value, but also the impact it could have on these other rights and values that both we as citizens and many governments would like to seek to protect.
Okay, let's see what happens as this trial goes on. Jennifer Huddleston, thank you so much for your insights today.
Thank you for having me.